Welcome to Inherently Distinctive.
Welcome back to Inherently Distinctive with Mark Goodman. Mark is a Nevada-based intellectual property attorney who helps startups, creatives, and small business owners protect what they've built through smart trademark and patent strategy. I'm Heidi Mack, and today we're diving into office actions. These can delay or derail your trademark if you don't handle them properly. Mark's here to walk us through what they mean, what to do if you get one, and how to improve your chances of getting your mark approved. This episode is Common Office Actions and How to Overcome Them. Welcome back, Mark. Thank you again for joining us as always.
As always, and we'll get it out of the way early. Let's smash that subscribe button, right? Since we're just
That's
going to
right.
now
That's
say
right.
this
I'll
every
say it
time,
again.
Andy, right? Get that done, and then we can get into the podcast, right?
That's right. That's right. So Mark, then, if someone is new to trademark or the patent process, what exactly is an office action, and why does the USPTO issue them?
Why? Well, I kind of wish they didn't sometimes, but they do, right? It's office actions can come in all sorts of flavors, right? But basically, the office is just saying you aren't ready to get your trademark or your patent yet because of X, right? And it can be multiple things. It can be one thing. Sometimes they're very easy to knock out. It's like, oh, all I need is a better quality image of this, right? Or all I need to do is do an amendment to change 2 words here and you're good, right? But a lot of times it's not. It's like there's a conflict with other patent applications or art, or there's a conflict with another trademark on the trademark side, let's say, right? And it's so you just have to read it and evaluate it. Some basic things about office actions, right? Um, so there's always a deadline, okay? So that's the first thing to think about. You get the office action, okay, what do we have to do when, right? And so for way it works right now for trademarks, you get an office action. Used to be you had 6 months, which is interesting because part of why people like me like trademark practice is that, you know, I should have enough time management skill to get something done in the next 6 months. You would hope, right? Whereas, those of us that practice in litigation. I mean, when I was in litigation, and I don't practice that anymore. But if you have a motion, right? Sometimes you'd have an opposition due in 10 days, and then you'd have a reply due in 5 days. What if I'm on vacation or something? You're in a stress situation, right? Trademark used to have 6 months, but now they've kind of shortened it. You have 3 months, except that if you want to pay for another 3 months, you can. And so then you can get your 6 months if you need it. Now, hopefully we can get this thing done a lot faster than that, folks, right? But at least you have time on those. It's the same thing on the patent side. You have 6 months is your statutory deadline, but they always set a 3 month, or depending on the type of office action, sometimes it's shorter than that. But most typically, you'll see a 3 month shortened period to respond. So what that means is you can respond within 3 months, but if you respond within 4, 5, 6 months, cost you more money, right? So that's really your time frame. And again, you still want to file all your responses quickly as you reasonably can, because otherwise you're just delaying getting your trademark or patent done, right? And on the patent side, that actually can be important if you because there's something called patent term adjustment, which beyond the scope of today's podcast, but just the general idea is that if the office is really, really slow on responding and doing things, you can apply to get extra patent term, right? Because patents expire in 20 years from the filing date. So you can try to extend that, but you lose that ability to extend if you didn't file stuff timely, obviously, right? So there's that. Um, So first thing is understand what your deadlines are and make sure you hit them, because if you don't hit the deadline, the application is going to go into abandoned status, right? And that's not good, all right? Abandoned is where patent and trademark applications go to die, right? And if you do go into abandoned status, you can do your option there is do a petition to revive it. But again, within a certain period of time, that's usually just a matter of giving them more money, but if you wait too long, it could be over, right? In trademark, if you go 2 months past the notice of abandonment day, then you really have to start over in almost every case, unless there's some dramatic tragedy you could prove up with the commissioner, right? And on the patent side, oh, this is a war story area here, because it is generally true the patent office, within the first couple months, let's say, if something goes abandoned because people screwed up or whatever, forgot about it, whatever have you, right? You can get your patent application revived. You file a petition, you pay a pile of money, and you fix it. But here's the problem: you can, when you file a petition to revive an abandoned application, you have to be able to say that it was abandoned unintentionally. Okay, sounds simple enough, right? And unintentional, right? Great, it's unintentional. But what does unintentional mean? Now, the patent office is not going to police this. If you, generally speaking, they can in the short run. They will actually police it if it's a long period of time, right? If you wait many months, they will actually try to inquire into the circumstances of how you missed this, right? But if it's just like a month or something, they'll be like, all right, whatever, we'll take your money and revive you. But if you end up having to enforce this in court, right, against a defendant, that is going to be a skeleton in the closet potentially, because they can take everybody's deposition about what was going on with this office action and try to determine whether it was really unintentional that you didn't make the deadline. And here's the thing: if your lawyer screws up and forgets about it, right? Not that that ever happens, right? That's unintentional. Yeah, that's good. We're fine, right? Your lawyer messed up, you pay some money, whatever. Or let's say you completely got this and didn't respond, you forgot other things going on in your life and didn't think about it. That's unintentional. But if you end up saying in your deposition, actually, I didn't want to pay the amount of money that my lawyer wanted. I thought it was ridiculous how much he wanted for that office action, and I didn't think it was worth it. But then later, or the product really took off, so I needed it. That your patent's gone, because that's not legally, that is not considered unintentional. The fact that you don't have enough money or don't want to spend enough money, otherwise everything's unintentional, right? And it's hard, because sometimes people even say, well, what if I'm just broke and I don't have any money? Sadly, that's not good enough. That's, if you are just broke, that's considered intentional, even though it arguably maybe isn't. But the case law precedent is saying that that is not unintentional, right? So you could be in a tough spot if there's an abandonment in that record. So you don't want to ever have an abandonment in the record, right? You just don't want to have it. And if you do, you do want to take that extra step of documenting exactly what was going on and why, at least contemporaneously, so that if you ever were in that spot, you'd have more defense to that kind of attack there. Okay, so yeah, that got me into one of these mission
Yeah.
critical things, right? Um, so yeah, so that's kind of the basics of office actions. You've got to respond, and the office action itself should tell you what it wants you to do. But quite frankly, depending on the situation, sometimes it's very simple, but it can be very complicated. I mean, office action responses are often just as difficult and complicated as a legal brief in court. They really are. So it just depends on what we're looking at.
So then, what are some of these, I don't know anything about this. Like, what are some examples of common reasons people receive these office actions, both trademarks and patents?
Okay, so starting over in patent, right? In patent, you're almost always going to get office actions, right? So when you file a patent application, the uh, the statistics are 88% of the time you're going to get an office action rejecting you on the first action, right? Only about 11-12% do you actually get a notice of allowance on your first action, right? And I always like to try to tell people this because so you're not surprised. Like, oh my God, we filed, we got rejected. It almost always happens, and you're fighting this thing through. Um, and so on the patent side, like if they'll find some other prior art that they think knocks you out, right? Or they'll find a combination of references prior, and these references could be prior patent applications, they could be prior patents, they can be just products on sale that the examiner finds on the internet, or even publications, right? There could be, let's say, an academic paper that discusses this technology, right? That can be something that can be used to reject you, right? Very famous case, right? Anything can be used to reject. Sometimes people assume that it has to be another patent application or patent. Doesn't have to be, right? To get a patent, you've got to be the first true inventor of the technology, regardless of how it was disclosed or used in the past, right? Famous case where somebody came up with some kind of gardening hoe or something like that, and the examiner actually rejected the person based on a passage in the Bible. Right? It's
Oh,
disclosed in the Bible, right? So here's your office action, right?
my.
Yeah. On patent, what you'll do is so those would be substantive office actions where you're saying, I know that's one of the questions we have is substantive versus non-substantive, right? Substantive means there's a legal issue, right? Either there's prior art you need to argue that you can get around, or you can amend your claims and say, uh, Mr. Examiner, as amended, we think that we're in condition for allowance now. Depending on the circumstance, sometimes that tends to be the better, more efficient way to get through, because I just feel like it's easier to say to somebody, okay, I understand where you're coming from, don't necessarily agree, but here we've made a few tweaks here, and now we really think this is in condition for allowance, versus to just go back at them and say, you're wrong, right? Here's why you're wrong, and argue it. But that sometimes works, and sometimes it's what you have to do, right? But as you can see, it's like just try convincing a Democrat to be a Republican or a Republican to be a Democrat. Like, it's just, you just run into things, right? But if you just kind of have a more nuanced position, sometimes that is better at getting things through. Um, so that's what you're doing on a substantive one. So non-substantive, a very common example of that is called a restriction requirement on a patent application, where let's say you file for something, you've got a bunch of different kinds of claims in there, which is typical. And then they'll come back first and they'll say, okay, we're not saying anything about whether this is patentable, but we need you to split this into multiple applications. So in almost all cases, what we'll do is we'll pick one and then split off the other ones if they want to. You could just argue that that's wrong too, but then you're spending a bunch of money arguing about something that doesn't have anything to do with whether anything's patentable or not. So I don't see the point of that most of the time. Might be certain circumstances for it, but generally you just pick one, go with that in your initial, and then consider whether you want to have separate applications branching off of your initial application that claim that extra material, and you can keep going with it all. Um,
So then, yeah, no, like so if
on the
somebody
trademark side, you have, again, same type of thing. The most common substantive problems are two basic things. One is a conflict with another mark, obviously, right? We think this is not registrable because look at this, or look at this, right? There's a conflict, right? And then you can argue about that. Or the other very common one is we think the mark is descriptive or even generic potentially, right? So those are the two most common, but there's all kinds of things that they can come up with. So, and then, on a procedural one, there's a lot of procedural non-substantive office actions and trademark. Like, they just want a better quality image of the document, or they just think that the specimen you supplied, which is the document showing that you're using it in commerce, isn't correct, isn't the right thing. You need to substitute it with something else
Mhm.
to show us better.
So yeah, no, if somebody filed this then on their own and they receive these, these office actions, and they don't understand, then what should they do?
Well, I mean, that's when you probably need intellectual property
Mhm.
counsel to help you most of the
Yeah,
time, right? I mean,
yeah.
we've talked about this a lot. People are filing stuff on their own. It's
Mhm.
just hard, right? I mean, I know that sometimes people are able to accomplish this, and so people think you can do it, but it's very difficult. Um, and because you got to just we don't have training in this field, right? And
Exactly.
how to do it. It's hard for us to do, honestly, right? And I've been doing this for 20 years, close to 20 years now. So it's still difficult.
So then, when they do come to you, then what can an attorney, other than you as well, whether it's trademark or patent, to overcome an office action that an applicant might struggle with alone? Then,
Well, it requires understanding the relevant law and the procedures and the rules and what's going on, right? And so you take a look at all of everything that's been filed, and then you also have your knowledge of law, and then you come up with a game plan. And it is kind of case by case, but there are certain patterns that repeat a lot. Like I've said, you'll have very typically, um, okay, there's this prior art, and we need to get around it. What do we need to do? What kind of amendment can we make? And then what kind of argument can we make, or both, right? Um, you know, it's really case by case, but you just need somebody with experience dealing with these kinds of things, because a lot of the same things come up over and over, right? Um, and it's just you just have to deal with it. And I think it's also important we don't need to panic just because we have an office action. I think most, even trademark and almost all patent applications face office actions of some kind. Trademark application, sometimes we can sail them through, but a lot of them have office actions too. So it's expected, right? This is just part of the game. It's part of what we're doing. So sometimes people come in and they're a little bit panicked, right? Just because, oh my God, there's an office action. I'm like, yeah, that happens all the time. So you need some calming force there, and just take care of it. That's all.
that sounds like great advice. I'm like, you're giving us all the information that we need. Thank you so much, Mark. Is there anything left that you need to tell the people out there before coming to you, or coming to you first before they do anything?
Let's see here. I'd say, um, with office actions, it's like I just said, part of the process. It's expected, not a surprise. And this is just where, like I said, it where you just need some good knowledge and experience applied to it, right? And that's really all there is to it. Um, and oftentimes, I have to say, it's can be the hardest part of the process in some circumstances, because I think, okay, you can prepare and file a patent application or trademark application. Sometimes the office action is harder because now you're being challenged, and it's like, okay, really, you think this is patentable over this and this and this, or the combination of these elements, and it's not obviously different from those things? You got to really be creative, and really, you got to have a good combination of analytical and creative skills to deal with some of this stuff. So it's kind of where the rubber really hits the road. So, um, yeah, it's kind of a lot of where we make our money in this business here,
Yeah.
is dealing with this, because it does suck.
Yeah. Nobody wants to have to do this, but you said it's part of the game.
Mhm.
So don't freak out, but come to you. Come to you
Yeah.
for this. Thanks for listening to Inherently Distinctive. If you've received an office action or want to file in a way that avoids one, working with the trademark attorney can make the process smoother, faster, and more successful. To learn more or to get help from Mark with your filing, visit goodmanlawnevada.com. And don't forget to like, subscribe, and leave a review if you like today's episode and need some help. And Mark, what do they got to do?
Smash the subscribe button. All right.
That's right. Thanks so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.